Good morning, everybody. My name is Laurie Sanderson. I'm a partner at Gowling WLG. Welcome to our second part of our COVID-19 Commercial Leasing Survival Guide. So let me say this, that our industry has been challenged both economically and philosophically. I think it's fair to say we're all scrambling to keep up with the information curve. Today, what we're hoping to do is help you with that by addressing three discrete issues demanding our immediate attention. The first, and probably most foremost in everyone's minds, is CECRA, the Canadian Emergency Commercial Rent Assistance Program. And then we're going to switch gears and address the impact of the emergency construction work orders or stop work orders that were implemented across the country in the context of landlord and tenant work and tenant exit obligations. And then finally, we're going to polish up our crystal balls and attempt to make a few observations about the reopening of closed workplaces in our various sectors. To do this today, I'm joined by three senior, or should I say well-seasoned, lawyers from our commercial leasing practice group. Firstly, Julie Lantaigne from our Montreal office, Darren Taylor, a partner in our Calgary office, Stacey Handley, a partner in our Vancouver office, and last but certainly not least, we're pleased to be joined by a partner in our employment law group, Max Brunel, who hails from our Vancouver office. Before we get started, just a few housekeeping items. If you're logged in on your computer and you don't see all the panelists on your screen, please go to the top right-hand corner of your screen and select the gallery view. Also, please feel free to send us your questions throughout the webinar by using the Zoom Q&A feature. And we're going to do our best to answer your questions in the course of the program. And if we miss any, we're going to do our best to answer them individually after the webinar. So to get started, our first topic is CECRA, the Canadian Emergency Commercial Rent Assistance Program. As you know, this is a forgivable loan to the landlord that's going to cover 50% of the gross rent payable by small commercial tenants. Information about this program has been painfully slow to be released, putting commercial landlords and their tenants in a difficult situation. On the one hand, you have tenants who are extremely anxious for assurances from their landlords as to the scope of the rent relief they're prepared to give. And on the other hand, you have landlords in a very difficult situation who aren't prepared to make those commitments without understanding in a comprehensive way the financial implications of seeking CECRA relief. Here to fill in some of the gaps is Darren Taylor.
Thanks, Laurie. So in looking at the CECRA program, I think you'll find some of the best information is available on the CMHC website. So we found that very helpful, and it answers a lot of the questions you'll have and tells a lot about the program. One of the challenges you may find is if it's not on that website, it seems almost impossible to find the answer to it. So look on the website directly. You can also sign up to get updates from them. And you know, this program was announced quite some time ago. It was actually about mid-April that it was announced. And the portal for the applications in the portal for the CMHC website opened this week. So starting on Monday, people were able to apply. And by today, all property owners across the country have had an opportunity to apply. And then starting tomorrow, it's open to everybody without, it's not categorized by the type or location of your property. So while the information's been coming out a little bit bit by bit over time, there are still a lot of, I'd say, questions unanswered. Some of which will be answered in the application portal, but some of them hopefully are going to come out over the next few days as well, or by specific reference to CMHC and asking them for assistance. So Laurie mentioned the program itself. It provides, to a tenant, it provides rent relief of up to, of at least 75% for qualifying small business tenants for the months of April, May, and June. Applications are made by the landlord. It's not the tenants who apply, it's the landlords who apply. And one thing to keep in mind is the applications are made by the landlord, and they have to make all applications for a property at the same time. So they can't make an application for one tenant and an application for another one at a later time. We believe that you can make landlords can make different applications for different properties separately. The other stuff about the, other details about the program, so it's 75% reduction for the tenant, or up to that, at least that much. The tenant has to pay at least 25%, does have to pay some of the rent. It depends on how much a landlord is willing to abate. The landlord has to give up at least 25%, and then the government will pay that 50% difference. There has to be a legally binding agreement between the landlord and the tenant for the rent to be reduced over the 3 months of April, May, and June. Has to go down by at least 75%, and the landlord has to agree not to evict the tenant for the longer of 3 months after June or after the application is made. So the applications can be made as late as August 31st. So there could be a moratorium on evictions if the application is made then until, right through to end of November. So that is something to keep in mind as a landlord when making those applications. So the landlord has to show that they qualify for it, and so does the tenant. The tenants have to they have to show that they're a small business, and the things that will be looked at. For example, they have to show that they pay no more than $50,000 per month in gross rent for that per location. So they could have more locations, but in that one location, that can't be above that rate. The tenant must have no more than 20 million in gross annual revenues at the ultimate parent level. Again, this is a small business assistance generally. And the tenant must show that they've had at least a 70% decline in pre-COVID-19 revenues. So there is some more information about how that'll be calculated, whether even for new businesses where you might not have had revenues, there is some information on the website about how to calculate that. So there were some prior concerns where the information hadn't come out. One of them is that it's now clear that the program does apply to landlords even if they don't have mortgages. There are some restrictions on what landlords can do with the money. For example, if the tenants there's two things that they say the money has to be used for. First is if it's been paid, if the tenants have paid rent, then the landlord will have to pay it back or give them credit. And then second, it has to be used for expenses for the property. And there was the implication, I guess, would be that the landlord can't be making a bunch of profit on this. Something that was a little confusing through the Ontario guidelines that initially came out seem a little clearer now. So the program is administered by CMHC, and they also have some assistance from other parties. So the MCAP and FCT are assisting with it. And to the extent that you have questions, as I mentioned earlier, the website's probably the best place to look. There is ability to email them and ask questions. I did do that last week. I haven't heard anything back. And then you can call them. I tried this morning on hold for about an hour and a quarter, had to get off for this call. Lori said she got on the call yesterday. It was only had to wait for 4 hours before somebody answered. So they're frankly overwhelmed, I think, with this program just starting. So the key benefits to this program is badly needed financial relief for a lot of small businesses. So that's really the big thing. So when you think of a tenant who really is down at least 70% of their revenues, that's got to be pretty damaging to them. The tenant doesn't have to do a whole lot of due diligence they don't have to show a whole lot of information as far as financial statements. Based on what we've seen, there is an attestation where the tenant says that, yes, this is true, and they have to swear. Kind of have to go on the line, and there's an integrity verification to make sure they're being reasonable. We don't know how long it's going to take for funds to be advanced, but what we would assume is that once the applications are made, this will be a relatively quick source of funds. So I think that's the intent. And from the tenant's perspective, it should be a relatively simple process. So there are some negatives to the program, some challenges with it. One of them is that there's still a lack of clarity on a lot of elements of the program. So there are some questions to be answered, and the nature of a program that's coming down like this, where you just don't know in advance, and they're making it up as they go to a certain degree. Landlords can't evict tenants for 3 months after the application. So if they apply later, that can be a challenge. And there are two other things is landlords have to disclose a lot of information about their property and about their finances. So you'll see that on the portal where they have to give a lot of information about it. It's really a lot of work for the landlords. I think that's the biggest challenge here, is that it's a lot of work for the landlord to go through this process. There is some difficulties about what the forms say, what the agreements say. And some of this information is on the owner portal with CMHC. We frankly don't even have access to it. So although my clients have told me about it, I have not been able to get on and go see it, because you have to be a property owner to do that. Let's see. So what we're thinking on, our advice right now is that, yes, as a landlord and a tenant, you're certainly looking at this program and considering it. As a landlord, you should certainly consider the program, and you should look at it, and you should make sure you understand it as well as you possibly can. It provides some very important assistance to your tenant. Yes, as a landlord, you may lose 25% of the rent, but perhaps 25% is a good deal compared to losing a tenant who just can't afford to pay anything and can't afford to stay in business. I would also say for tenants, be proactive. Look at the program, get on the website, figure out what the information is that's required, because it's not enough to call your landlord and say, you need to do this, you need to do this, if you're not ready and you don't have the information they're going to need. One last thing for landlords is you should check with your lender, because in order to enter into a program like this, you need your lender's consent. I would expect lenders would be relatively cooperative with a program like this, but you do need their consent, so you should check with them in some way.
Darren, we actually have a couple of questions. One was if we're able to get the final version of the secret documents without registering on the application portal. And as far as I know, when I spoke with CMHC yesterday, they are not available except through the portal. And the second question was, sorry, I'm just trying to look here. I just missed it. Whoops. It was a question, I can't find it, but it was a question about whether or not you can amend the rent relief agreement and the loan forgiveness. And I know for certain, having spoken with CMHC, you cannot amend the loan forgiveness. It's going to be available in the portal, and really it's a function of pressing accept. And on the rent relief agreement, CMHC was being very clear that that the form of agreement that's in the portal is a PDF that allows a little bit of modification, but they're very, they're telling us anyways to be very careful about not amending it to the extent that you can.
Right, and I did notice in looking at it, so that they don't want you to amend it because you have to make sure you qualify for the program. So if you change it too much, you might disqualify yourself. But it does say you need to make sure it's appropriate for the law in your province and area, and that it applies to your situation. So they are downloading a lot of responsibility there onto the applicants. But yeah, it's so that first question, I'd say it's kind of hard to find this information on the portal unless you are. It's hard for your lawyer to find it because we don't have access to it directly.
Yeah. Thanks, Darren. Really appreciate that. As you noted, only small tenants are actually going to be able to qualify for CECRA relief. What's happening with large tenants, Stacey?
I mean, large tenants are a different beast, and I know many of you landlords out there have a number of these large tenants in your portfolio, and their negotiating power is going to be quite different than that of a smaller tenant. So as Darren went through, the smaller tenants are the ones that qualify for CECRA. So if they're paying $50,000 per month, that's gross rent. It's got to be no more than that per month at that location. And they also need to generate no more than $20 million in gross revenue annually, and that's at the parent level. So there are a number of tenants that aren't going to qualify for this relief, but also will be struggling. So landlords and tenants are looking at in those situations what they can do. And this is what I'm seeing, and some of the things that are going on. And I'm sure that you out there as landlords and tenants have been seeing some of this as well. So these larger tenants definitely have a definite bargaining strength and power with their landlords. They have got a large square footage for their premises, and it would be really hard for landlords to relet that premises if they were to terminate or leave the center. So landlords are going to give them probably a bit more leeway because of that, because they know that ultimately if they're not there, it's not going to be easy space to fill. They probably have a lot of financial leverage with the landlord as well, because they also are probably a large component of the rental that comes in every month for that center. So landlords are also going to be well aware of the financial power that those larger tenants wield at that center. So they're going to be incented to work with those larger tenants and try to come up with some sort of arrangement. Hopefully, and we'll talk about this a little bit later, but the covenants of those larger tenants in many cases are strong. And so the landlords will also have some comfort that these are the tenants that are going to weather the storm. There are some exceptions to that. We'll be talking about that a little bit later. But hopefully they have a covenant that they have a bit more comfort in than maybe some of their smaller or more individual tenants that may be struggling a bit more during this period. They're often repeat customers as well. So you landlords out there know you've got a number of tenants that it's not just one center, you've got them in your centers all across Canada. And so that also makes a difference. You're not looking at this as a one-off. This really is a larger kind of big picture analysis and discussion that you're going to be having with that tenant. You probably have a longer term relationship with them if you've got them in multiple centers. So that's also going to impact how you deal with that tenant and what sort of, arrangement or negotiation you come up with them. I know a number of large tenants have taken some more aggressive stances as well during this period, and I'm seen many of the letters, and I know that landlords have received letters from some larger tenants that have basically said, we're taking a look at this, and at the moment, here's what we're paying. And so a number of these larger tenants have tried to dictate terms. And that has put landlords in a difficult position because they do have, real financial power often within those centers. And so landlords have, had to come to the table often and work with those tenants in order to come up with some sort of arrangement, hopefully on a temporary basis that works for both. There are co-tenancy concerns. We're going to talk about this a little bit more later, but I just want to raise it now. Co-tenancy is an issue that comes up with large tenants. So as a landlord, you're going to want to know what co-tenancy rights you've given in your center, and if any of these tenants are named co-tenants in any of your other leases. What you don't want to have happen is take an aggressive position with one of these tenants and then have them stop operating or leave, and then that triggers a domino effect of other tenancies that then are affected in your center because they've got co-tenant rights. On the landlord side, so it's not all tenant, on the landlord side, I think there are some things that you can look at. One thing I've been talking with my clients about as landlords is just to take a look at those leases and see what special rights those large tenants have in their leases. They often do have a number of special rights, things like exclusive use rights, no bill covenants, various options to renew, expand, perhaps retract. And often those are tied to some sort of required condition. So they aren't just outright rights, they may be tied to not being in default during the term. So that will give you as a landlord a little bit of leverage if you need to actually get that tenant to the table and say, it's not all one-sided, you actually need us too. So take a look at your leases on that because I think that will help. And then just the last thing is cross-default provisions. Again, if you are a tenant that's in multiple centers, I think you need to be careful. If you're taking, sort of an aggressive position or just a position with your landlord that here's what you're paying, you need to make sure you don't have cross-default provisions in your other leases with that landlord that could trigger defaults in your other centers as well. So that's, Lori, that's what I'm seeing on the large tenant front. They are in a different position. They don't, unfortunately, have at the moment anything to claim on, for the government programs. They are in a different position there. They do have some more bargaining power and leverage, but I think, it is really coming down to just individual negotiations with their landlords.
Thanks, Stacey. I'm going to now switch over to our second kind of discrete topic. So across the country, we've had non-essential construction projects been ordered to temporarily stop as governments grapple with trying to flatten the curve. And this has and will continue to have a material consequence. And suddenly, force majeure, which we never heard of before really, is suddenly the word du jour. And so Julie, if we can switch to you and ask you exactly what is force majeure and how does it relate to these particular construction delays?
Yes, so hello everyone. So exactly, Laurie, my aim is actually to provide deciders with a clearer understanding of the force majeure concept in 3 minutes. So it's not going to be an over-exhaustive legal explanation, but I find that it's not well understood. And I also find that when making decisions to negotiate agreements on, you need to negotiate from a point of knowledge and strength. So understanding the force majeure provision or concept is going to help in this, in those negotiations. So contrary to the pandemic mantra that we are all in this together, force majeure concept, like you said, is not a new concept, and we're not all the same under the force majeure concept, even though ministerial decrees or pandemic applies to everyone. It's quite the contrary. Force majeure concept applies per person, per obligation. It's a very specific analysis that you have to go into it. So in a nutshell, what is the force majeure concept? Well, it's simple. It's a valid legal excuse to not comply to your obligations. Simple as that. It's a legal excuse. I'm not going to comply to my obligation to do in a certain delay or to pay. So when we're looking at construction delays and impact on leases and delivering premises with work done or leaving premises and vacating, we're talking about delays to do in a certain delay, and how does it work then? So we have what we have to do to be excused. The first thing we need to do is to look at the specific obligation we're looking at for this specific tenant. And then we have to look in the lease. Do we have a clause of force majeure that applies? In Quebec, there's a provision in the civil code as well, but it can be modified in a lease. And then it's not sufficient to say, oh, I have a clause of force majeure in my lease, therefore I'm excused, or the landlord's going to say, well, you know, there's nothing I can do. It's not sufficient. You need to understand whether this specific obligation is affected really by this clause. Does it really tie into that clause? And that also is not sufficient, because you need to demonstrate as the person who has to provide the obligation that it was impossible to comply with the obligation. And by impossible, we do not mean really difficult in the circumstances, or, you know, with a lot of troubles, and I tried and I wasn't able in some way, or very onerous. You know, it would have cost a fortune in order to move out my stuff and store it in another place until my new space is ready. So onerous doesn't qualify. It really is impossibility. And we need to remember that the courts are going to scrutinize your explanation as to whether did you do everything? Did you try to accommodate? Did you try to find ways to do it faster, although there were delays? And so you may be excused for a portion of the delay, not all of it. And you will have the onus of proof. So, and it's only then when you have the obligation, the clause, the link to it, the demonstration it was impossible and you did everything you could at great lengths, that you will have a valid legal excuse. And so beware landlords and beware tenants. It's not simple. It's not as easy as I have a clause, I'm not doing it. And case by case basis. And now Laurie, in your clauses, you can give examples, a lot of them.
So what I really take from what you're saying, Julie, and what I really like is your description of it as a legal excuse. and that it's not a get out of jail free card, that it's actually quite difficult. So with that in mind, let's talk about this in the context of landlord work and tenant work and exit obligations. So as we all know, many commercial lease transactions are going to require the landlord to do certain work. And that may be just readying the premises, you know, cleaning the carpets and refreshing the paint. But often that work is really significant. It can be a turnkey premises, or it could even mean building a building on a pre-construction lease. And this raises a number of issues. For tenants who have received force majeure notices from their landlords, I think the two biggest issues are, I understand the work is going to be delayed, but surely my rent is delayed. And the second is, oh my goodness, I have to vacate my existing space before my new space is going to be ready. So to deal with the rent question first, there's a number of issues. In many leases, the landlord will promise to do the work, but it doesn't stipulate by when. And even if there's a deadline for the landlord to complete its work and force majeure applies, that doesn't necessarily mean that the commencement date is extended. And if it's not extended, then the rent due date is not going to be extended either. So tenants really need to check your lease to see if the commencement date is likewise extended. For tenants with fixturing periods, you need to see if the expiry date of a fixturing period is going to be likewise extended. Most often, it'll say that the fixturing period expires the day before the commencement date. So we're back to trying to decide if the commencement date is going to be extended. And if not, then this delay is going to encroach on your fixturing period. So even if you have a commencement date that extends, and you've got then the extension of the date by which you have to start paying rent, tenants need to deal with their existing space. And again, there's a number of issues. Most leases will include tenant exit obligations. And whether that's to remove, their own trade fixtures or certain leasehold improvements, or it may extend to reinstating their premises back to, the landlord's then current base building condition. All of these involve construction, and most leases will require that those exit obligations be completed before the end of the term. The force majeure provisions in the lease may extend the tenant's obligation to complete its exit obligation, but that doesn't necessarily protect them from the overholding provisions of the lease. And this is an issue as well for tenants who are fortunate enough not to have any exit obligations. The force majeure provision isn't normally going to protect a tenant from the obligation to pay overholding rent if they overhold, and whether that's at 150% or 200%. The only time I've seen kind of an argument that you can use the force majeure for the overholding is if there's a specific clause in the lease where the tenant is required to surrender, in which case that may open the door for arguing that because of force majeure, you're not able to surrender on that expiry date. And finally, there was the Supreme Court case in 2014 called Leasing. And in that case, the Supreme Court said that the common law imposes on every party to a contract a legal obligation to act in good faith and a duty of honest performance that aligns with reasonable commercial expectations of the parties. That said, that protection doesn't create new obligations in the lease. But what it does do is it dictates how the parties have to exercise and abide by the existing terms. So there may be an argument under Leasing to deal with if you're being delayed to get your exit obligations completed. Likewise, landlords are also grappling with construction delays, but generally speaking, they're going to be in a better position. Most leases that include landlord work will not stipulate a completion date. And those that do will almost always say that that obligation to complete the work by that date is subject to force majeure delay. In addition, most landlord leases release the landlord from liability if they're not able to deliver the premises to the tenant on the promised commencement date, if an existing tenant fails to vacate, or if they're delayed for force majeure. What we all need to understand, and what I think Julie was mentioning, is that when you give a party the legal excuse of force majeure, what you're doing is you're transferring risk. You're transferring the risk that that obligation isn't going to be performed to the other party. I've tried with a couple of large tenants to try to argue that it's unfair for the tenant to bear 100% of the risk of force majeure delay. But I've had really limited success. This is just the industry standard. Finally, when a landlord or a tenant claims force majeure, it's important you do so in accordance with the lease. And generally speaking, it's going to require you to give notice to the other party of the delay. And very often it's going to require you to provide a workaround plan and then to follow that workaround plan. My final comment, and I think Julie, you're going to speak to this, is for landlords that are doing new deals right now, and there are happily some of those, the pandemic is not an unforeseeable event. And so a work stoppage that the landlord can now foresee is not going to be an unforeseen event. It's a known fact. And so they need to address it. Julie, you had some other thoughts on that as well.
Yes, you're right, because we are already hearing that there may be a second wave of the pandemic, and with this will come potential additional restrictions on ability maybe to continue pursue construction, or in what manner, or for what industry or regions. So it is expected, it is possible. And when we look at the definition of force majeure, at least in the civil code, but you know, common law concepts and force majeure clauses and leases pretty much all, you know, represent the same ideas, which is it has to be, a force majeure has to be an unforeseeable event, it has to be irresistible, and it has to be external to us. So the question is valid as to whether, knowing the potential second wave and that we may expect further restriction, will it be easy to approve? Because we are going to have the onus of proof that this is an unforeseeable event. But specifically, so we don't know yet if it's going to be an unforeseeable event or not. Would the courts consider that it was not, you know, a person could not know that the court, that there would be a ministerial decree at this moment in time in that particular situation? Or are they going to consider that, like floods in a region every year, that, you know, you should prepare for this because it's expected? So therefore, if we are negotiating new deals or agreements to deal with the present force majeure situation, what I've seen on my side is that the parties are largely taking the position to discuss what if in the future. And my recommendations on that is actually, if you are going to agree, like you said, Lori, it's a shift of risk, the cost of doing business, the new normal. Who is going to take the risk of not receiving the rent or not paying its lender, not having the money for that? It's becoming like a business risk, a cost of doing business. There's a negotiation how you want to split. Can you split it? Do you feel strong in the position that it's not going to be foreseeable, or will it? And if you negotiate and you agree to give some slack on and share the risk, you want to circumscribe very much to that specific pandemic and not create another order that you don't have in the lease normally, because normally your lease already provides for a situation of force majeure.
There's really no excuse going forward, is there? I mean, before you could say it just was beyond our possible expectation. But going into these deals, I think you're absolutely right. You have to be dealing with this now, that there's likely to be a second wave. Just before we leave this topic, we did have a question asking for the citation for Bassine, and I will send it out after. But if you just Google, and the name is BHASIN and Supreme Court of Canada, that's going to pick it up for you, but we will send it out after. Our third and final topic to address is the reopening of workplaces. And Max, you're going to start us off with a high-level summary of the guidelines and protocols, please. And then I'm going to ask our panelists to take out their crystal balls and give us your thoughts on the challenges facing the various sectors and what the new normal might look like. But Max, let's start with you, please.
As mentioned, I'm an employment and labor lawyer, so a little bit of a different specialty than the folks who've been chatting so far today. As you can imagine, through the course of this pandemic, there's been just a huge variety of employment issues. And I think as they may be germane to today's topic, I wanted to chat briefly about occupational health and safety obligations. And this probably is not top of mind for many of you in a low-risk office environment. It's obviously very live at industrial sites, mines, those types of facilities, and you're probably not thinking about them too often in the normal course as far as an office environment goes. But now, what we're seeing is the occupational health and safety bodies across Canada, they're all provincial, have started to implement guidelines for return to work protocols. And they were a little slow to do this. The initial sort of, the calls I was taking initially were, well, what do we do? We're still having our folks come into the office. What steps do we need to take? And the advice was, well, look, you got to look at the public health authorities and see what they're doing and try to match that. And so the OH&S folks are a little slow getting up to speed, but now they're there. So I think what you'll find in each province is if you go to your, in BC, for example, if you go to the WorkSafe BC website, you'll see their recommendations are laid out, and boy, is it detailed. BC's, for example, runs about 8 pages long. Now, the good news is this: these are not, there has not been amendments yet to any of the legislation. These are recommendations, okay? So you don't have to strive for perfection here, but you do have to take these recommendations into account. So the clause that I think is going to loom large for employers in all jurisdictions in the office environment is the general duty clause. And what that is largely the same in all the provinces, requires you to take all precautions that are reasonable in the circumstances. So, the question then becomes, well, what's reasonable in the context of COVID-19? And that's where you've got to double back and check out what they're suggesting for their guidelines. So, and I won't go into a high level of detail here, but what are some of the examples we're seeing? Okay, practice social distancing within the workplace. For your buildings, obviously, you're going to have access and egress issues with respect to the entrances and exits being segregated. You're going to have capacity recommendations for elevators. So as far as the building itself is concerned, those are quite consistent across the board for all the provincial regulatory bodies. And then you're going to see a whole host of other recommendations, asking, your tenants will be asking or be forced to ask, where do people congregate? Where can we create some space between people? What are we doing in terms of cleaning and hygiene for the office? That sort of stuff. So again, it's worth taking a look at these. And it speaks to the importance of ensuring that you have your employers, your tenants have a joint health and safety committee in place for their workplaces. And the reason for that is that they're going to have to do a hazard assessment that goes through exactly some of those items I mentioned. What have you done? What steps have you taken to ensure that you're minimizing the risk of transmission in the workplace? And so those will be important because to the extent that complaints are filed, you're going to want to make sure that you've documented your joint health and safety committee meetings. You can fall back on those notes. You can show the regulator that you've considered appropriate hazards and taken steps to try and minimize them. Again, recognizing you're not striving for perfection, but you've got to take all reasonable precautions in the circumstance. A couple things I wanted to flag for you, just what I'm seeing in my practice and some of the types of complaints that I think people can expect to see now. One would be work refusals. So in, under each provincial occupational health and safety piece of legislation, a worker has a right to refuse work where they perceive there are unsafe circumstances. Now, the traditional way in which you're thinking about this is obviously, fall protection, for example, at an industrial site. But already we're seeing a rise in claims where people are saying, look, I just don't feel comfortable coming back to the office. And so the idea, if you get one of those, after you've taken a number of precautions to show that you're doing what you can to minimize the risk, the idea is you try to work collaboratively with the employee to solve that problem. And really what you're going to be doing is saying, look, here's what we've done. Here are the guidelines from the provincial OH&S authority. We feel we've done the best we can. We've taken all the precautions that are reasonable in circumstances. You should come back to work. If that employee continues to refuse, you've then got an opportunity to involve the regulator. Not that anybody wants to do that, but you can get a decision issued from a preventions officer at WorkSafe BC, for example. And then ultimately, if you don't like the decision that officer gives you, you can appeal up. So the hope is you don't have to go there, but the idea is to work collaboratively with the employee. So one thing I've been advising my clients is don't jump too quickly to the termination letter that says, look, if you don't want to come back, that's fine, but you don't have a job with us anymore. So take some time to work collaboratively with those employees who are refusing to return. The other issue I think that you're going to see from an employer perspective in the work refusal context is there's going to be a lot of, and I've seen a multitude of them already, requests for accommodation. And mostly it's going to be family status type requests because we don't know what's happening with schools, universities. Childcare is going to loom large. People are going to be, potentially unable to return to the workplace. So I think you can expect an uptick in those sorts of complaints, and you've got to be prepared to work flexibly with those people in the context of your overall return to work plan, which may have staged or staggered return built into it. So something to prepare for. I can tell you in the last 2 weeks, I've seen already probably 6 or 7 complaints like that coming forward to employers. So again, the key takeaway to keep in mind is, have a look at those recommendations. You don't have to be perfect, but you've got to show that you've taken them into account and taken some reasonable steps and document that process through your Joint Health and Safety Committee. Lori, over to you.
Thank you. Darren, what are your thoughts on the new normal in the context of strategic or anchor tenants?
Well, I think a lot of the things that are going to affect these anchor tenants or strategic tenants is going to be really just business going forward. So what's going to happen to them? Are they financially strong enough to make it through the downturn now? And are people going to, if we're talking primarily about retailers as anchors, are they going to have enough business that they're going to be able to stay in business? Or are they going to be consolidating locations? Or what are the sort of things that are going to happen? We look at how a place like a mall is going to practice social distancing and how many people they're going to allow in. And that's going to, that could make a difference as to whether they're financially viable. And when you look at these changes with the smaller retailers and then with anchor and strategic tenants, when one of those changes, it changes the mix of a whole shopping center. So it can change the number of people that are brought in and the type of things people are looking for when they get there. So I think that clearly it's going to affect a lot of businesses. So things I think they're going to be looking at outside of pure finances, I think they're going to be looking at their leases closely. Some of the leases, particularly for these large tenants and anchors, have co-tenancy clauses, or they have some provision that other tenants have to be there, or that they have exclusive uses. They have protections built in. And these are unique clauses. They're very specific to a lease. I don't think that a court is going to look at them broadly, but they're going to look at what that very specific lease will say. So one of the things they're going to be doing is looking at their leases. They're going to be seeing if anything has changed, and if if there's, maybe they'll be looking for rent relief or sometimes ways out of a lease. But if those anchors were to leave or not be able to make it, that's going to affect the smaller tenants too. So it's really it's kind of a ripple effect that you look at these big shopping centers as an example, the big malls, and they all kind of need each other. We go there you may go there for the Bay or Nordstrom's, but you enjoy the smaller retailers that are there as well. And it's kind of lacking without both of them together. I would suggest this might be an area where force majeure is looked at by both the landlords and the tenants, where a tenant says, I can't do this because of this, or the landlord says, well, I couldn't do it because of this. So it's not the pure force majeure where you're looking at construction or where we're looking at rent, where for rental purposes, force majeure tends to be in the landlord's favor. It might be a little more creative at this point in time for this sort of application.
Excuse me, thanks, Darren. Stacey, you act for many, many retailers and restaurateurs. What do you see on the horizon?
Yeah, I mean, in the retail space and restaurant space, I mean, that's the group as a whole that's really been hardest hit by COVID-19. It's been quite devastating for many of those groups. Just to give you some stats that I'm sure some of you have seen, but they are quite sobering. In March, so not even in the bad month, we're still waiting for April's numbers, but March numbers 2020 for retail sales were down a record-breaking 10% in Canada. April numbers are obviously expected to be worse because of early March, most of those retailers were still open. Statistics Canada's projecting it's going to be closer to a 20% decline for April once those numbers come out. But these numbers are deceiving. And so you think, oh, I actually thought it'd be worse. These are propped up by those retail tenants that actually did better. And so there's definitely a group of tenants that have done well during this pandemic because of what they sell. So, I mean, the obvious ones, grocery stores have done very well. I think grocery stores and liquor stores combined are up something like 25%. It's significant. So you've got those sorts of tenants that are actually, I think, distorting those numbers that are in the 10-20% range as a whole. There are sectors, as I mentioned, that have done well. So if you're a landlord and you've got tenants in some of these sectors, they probably should be paying their rent because they've actually gone up. So these are things, obviously, grocery stores, drug stores, liquor stores, anything to do with home improvement has done quite well during this period, painting, gardening, landscaping. Home exercise equipment's gone through the roof for obvious reasons because all the gyms are closed. Electronics has held their own. People are buying TVs, gaming devices, computers. Home office has done well if you're in that space. Indoor, outdoor entertainment, anything to keep the kids busy, air hockey, pool tables, shuffleboard tables, outdoor, getting a swing set or a trampoline these days is like winning the lottery. You've tried to do that, I know I have. Pet supplies, arts and crafts. It's really a very, random range of things. But what they basically coined it as is comfort spending. So what people during this epidemic have been doing is spending on things that make them sort of feel safe or comfortable in their own home and make them happy. Just a fun fact, which made me laugh. Sale of bread makers is actually the top. I actually thought it would have been like Peloton bikes, but bread makers has actually gone up the most, 600% increase in the sale of bread makers during this pandemic, which is super random. But again, that speaks to just this concept of comfort spending. The downside, unfortunately, is that other sectors of the retail industry have been absolutely devastated by this pandemic. So retail sales and clothing accessories were down 51% in March. Again, April numbers are expected to be worse because many of them were fully closed in April. Car dealerships reported a 40% decline in new car sales. Gasoline stations were down a 20% decline in sales. Again, these are March numbers. Now, online sales offered some relief for some of these tenants, but not nearly enough to make up for sizable losses in many cases. So non-essential retail stores, which were closed in March, April, and May, are starting to reopen across Canada. And as Max has mentioned just now, they do have a number of limitations placed on them in those reopenings to address social distancing and various sort of, work safe and health requirements. They've implemented new protocols, and a lot of these things that they're required to do to reopen are going to increase their costs at a time when they're actually struggling and have, gone through a pretty difficult period. Even before COVID hit, I'm sure a number of you in this space know that bricks and mortar retail has been struggling now for a number of years for various reasons. I was just speaking at a conference pre-COVID, I think it was like early March, on this very topic and what's been termed the retail apocalypse by many in the media, and just this decline in how we're spending, our spending habits and how we're behaving as a consumer. And this was already well underway and had, has been increasing in the last number of years, a number of closures and bankruptcies of, fairly sizable retail companies that are, had been a fixture in many of your malls, but then, just things have changed and they're just not able to compete at the same level because of changes in consumer spending and kind of needs. So this has really hit at a horrific time for a number of these retailers. Anyone who was on the bubble or who's having some struggles pre-COVID, this really is a black swan event and just the perfect storm of what they didn't need at this time. So just recently, credit ratings have been downgraded for major retailers like the Gap. The Gap has been closing stores lately, as many of you know, but they've been downgraded. Macy's, Nordstrom's on this list now, which they hadn't been in the past. The parent companies for a number of these stores that are high-profile stores in many of the outlet malls, so like Michael Kors, Versace, Jimmy Choo, their parent company's been downgraded. So is the parent company to Coach, Kate Spade and Stuart Weitzman, and L Brands, which is the parent company to Victoria's Secret. So it's a list of very high-profile, very well-regarded companies that are feeling the impact of what's going on here. The concern is that retail tenants are going to have a difficult time rebounding from this. These are big losses, and it's not expected to come back right away. There's concern or just a thought that the spending habits that we've developed during this time aren't going to fully rebound. Obviously online shopping has only been increasing in recent years. We've certainly gone to even more of that during this period. That's likely not going to all come back. Things like online grocery shopping, even that many people didn't do, is now the norm. Online liquor store shopping, which again wasn't entirely the norm, has become quite popular. So the idea is that some of our current habits are not going to change, and that there will be a new reality for some of the retail tenants. This obviously is going to have a pretty significant impact on landlords that have a number of these tenants in their centers that are facing these struggles where their consumers just aren't behaving the same way as they've used to, seen them behave in the past. Restaurants also have just faced significant challenges during these times. They're now starting to reopen. But again, like Matt said, they've got requirements for social distancing, requirements of work safe and with the health authorities that they're going to have to meet. In many cases, those are going to cause increased costs for increased cleaning, increased improvements that they're putting in right now to allow for the capacity that they're allowed to bring back. Restaurants are only allowed to bring back 50% capacity at the moment. Those of you in the restaurant industry know that the margins were already tight on 100% capacity. 50%, it's certainly not sustainable. So the restaurants that are going to survive this are the ones that can sort of weather the storm for this period when they are under these restrictions. And a number of them are trying to come up with different ways to increase their profits. Takeout has done well for a number of restaurants. Some of them have increased what they're selling, and Earls went into some grocery store sales, which I think they've done quite well with. But it really is not feasible for restaurants to be at a 50% capacity for a very long time. Some municipalities are looking at loosening current restrictions on outdoor space and patios to allow for some increased space for those restaurants to have more seating to make up some of this money. But it really is quite challenging for the restaurant industry right now to to just make the numbers work. It's estimated that up to 30% of restaurants will not survive the reopening under these new restrictions because they simply can't take those losses for the period that they could be operating at on these new rules and on these restricted seating. A number of people have looked to China to see, because they're a number of months ahead of us, just to see how retail's responded there and how restaurant industries responded there. And it's been challenging there. So they've reopened, they're a few months ahead of us. To date, 15% of restaurants in China have gone bankrupt. And so the concern is that, our numbers here in Canada, North America, aren't going to be that different. And I think, landlords are, definitely looking at this very carefully because often landlords, in addition to large retail sort of tenants, have got a restaurant or two in their center as well to accommodate the kind of entertainment feel and bringing people to the center for multiple reasons. And so, I think everyone's looking very carefully just at the covenants of their tenant base and hoping that they're strong enough to be able to kind of weather the storm and get through to, when hopefully there's a vaccine or when there's a change in basically the landscape so that people feel more comfortable going back to their old habits of going and sitting in a restaurant or sitting in their local pub and living, life, spending in the way that they were doing before March.
Thanks, Stacey. Those are really sobering numbers. Really sobering.
Yeah, no, they're pretty sobering.
The office tenant experience, during the pandemic has really been very varied. For many, the transition to remote working has been much more seamless and successful than anyone would have anticipated. Part of the questions, I think, being bantered around is the extent to which the so-called Zoom worker is going to want to continue to work remotely and to what extent employers are going to be able to accommodate that. For those returning to their offices, there are significant practical challenges to be faced. In office buildings, you consider for the most part are located in a central business district or a technology hub in a suburban neighborhood. All of that requires staff to take public transport or public transit. And until the pandemic's in control or there's a vaccine or we hit the herd immunity is achieved, many are going to be very reluctant to use public transportation. And then once you arrive at your building, you're going to be really quickly reminded that these were built for high density use. And as Max was mentioning, we have shared common areas, elevators, food courts, washrooms. I mean, how are landlords going to manage the social distancing? I know everyone's got their heads down trying to deal with this. There are suggestions about dictating arrival, departure, and lunch times to try to deal with or control congregating. And then we get to the larger question that's facing the industry as to whether tenants are going to upsize to deal with social distancing within their premises and the fact you can't use, bench seating or hotel offices. Or are we actually going to see a downsizing in the requirement for office space as employers, office tenants adopt remote working to a much larger extent than we've seen previously? It all remains to be seen. I see that we're at 12:59. So let me just say that we thank you for your questions. I know we got to some of them and a number we did not, so we will do our best to reply to those individually. Let me extend my thanks to our panelists, Julie Lataigne in Montreal, Darren Taylor in Calgary, and Max Brunet and Stacey Handley in Vancouver. Thank you. And most importantly, thank you everyone for taking time out of your busy day to join us. Please feel free to reach out to any of the panelists or any of our many real estate leasing employment lawyers at Gowling's. We are definitely here to help. Thank you very much for joining us and stay safe.